for a period of 1 year. Yevhen Volodymyrovych Didenko has more than 5 years of experience as a judge and is fluent in the state language at the second level. That's a general information regarding our candidate. So, Mr. Oleg, over to you. Yeah, and I give a floor to the head of the PCA, Mr. Robert Broekhuizen. Mr. Robert, please, over to you.
Thank you, Mr. Chair. Morning. I'm pass the floor to Jessica, who's the rapporteur on your case.
Good morning, Mr. Yevhen Volodymyrovych. Thank you for joining us all today to discuss your candidacy for the High Anti-Corruption Court. My name is Jessica Lott-Thompson. I'm a lawyer from Canada. The panel has already been introduced to you, so I'll proceed directly to questions today. Do you have any questions or concerns before we begin?
No, thank you.
For the translation and for the interpreter to be able to hear you clearly, I ask that you, make sure that your microphone is on and speak directly into the microphone with a strong, loud voice. So I will ask you questions today about a few different themes. First, I'll begin by asking you some questions regarding your financial declarations and your financial situation. And I'd also like to begin by acknowledging the materials that you have already sent to the PCIe, documents, photographs, and your compliance with sending thorough materials to us in advance through multiple rounds of written questions. So thank you for your participation in that regard. So according to your declarations for the years 2020, 2022, 2024, you and your wife received monetary gifts from your mother, Tamara Lagunowska. In 2020, there was a gift of approximately 220,000 hryvnia. In 2022, there was a total of multiple gifts totaling approximately 152,000 hryvnia. And then in 2024, again, another approximately 150,000 hryvnia. Since your mother was retired and a pensioner at that time, can you please explain how was she able to have the financial means to provide these monetary gifts to you and your wife, to your family? And can you explain why she would have done this?
Thank you. Yes, indeed. My mom, she's a pensioner, but I have already provided to the Commission certificates of income of hers. She has quite a high level of pension as of 2019. If I'm not mistaken, it was 40,000 hryvnias then. It became 49,000 hryvnia per month. Then, in 2020s, the gift was received at the amount of 220,000 hryvnia in order to pay a part of first installment for purchase of a vehicle. At that moment, our family didn't have money to pay it, and according to the loan agreement, 50% should have been paid as a first installment, and another half, 50%, could have been taken as a loan almost without any interest. So partially we used our funds, and partially my mom provided funds. I provided detailed calculations that indeed there was a financial opportunity for her to make such a gift to us. Then, in 2022, the amount of 90,000 hryvnia I received as a gift from my mom, as before the start of the full-scale invasion, we planned to sell an apartment and to buy another apartment of a bigger area. And correspondingly, we didn't have enough money, a little bit. And it was January, February, when my mother gave me 90,000, and partially my wife has also received to cover those expenses. And another sum, which I mentioned, these were already transactions after the start of the full-scale invasion. That was her wish, given the fact that we left that territory, and in order to financially support us, she said that she wants us to spend this money on her grandchildren, to buy something for them. Yeah, something like this.
You mentioned that you had provided detailed financial calculations and supporting materials regarding your mother's income, and thank you for providing those in advance to the PCIE. Can you tell me also an additional issue related to your declarations for 2015 to 2019? You declared the use of an apartment with the total area of 51 square meters in the city of Melitopol, Zaporizhia Oblast, on the basis of a lease from the 15th of August, 2015, with a declared value of approximately $9,000 US. The owner of the apartment was indicated as your mother, Tamara Logonovska. Can you please explain why the declared value of approximately $9,000 US, how that corresponded to the market value of the apartment when your mother bought it, and why the value of the apartment was much lower, perhaps approximately half of what could have been the expectation for a market value for a similar apartment at that time when your mother purchased it?
In 2015, my mother purchased this apartment. As she has explained to me, and as the equivalent to the foreign currency, it was at that moment roughly $9,000. And at the national currency, the amount was 193,000 hryvnia approximately. The figure was something like this. At that moment, this apartment had certain drawbacks. To my opinion, those drawbacks were quite significant. So I've already mentioned that the apartment was located on the first floor. There were significant problems with sewage, and the owner has preliminarily informed about these problems. And another registered person was there but didn't reside there at the moment of conclusion of the agreement. And it also impacted on the price of the apartment. Regarding prices which were on the market at that moment, I knew that the range of prices was huge, depending on different factors. At that moment, as far as I remember, those options that we have considered, they were in the price range from like $12,000–$13,000, and these were real prices for which the owners were ready to sell their apartments. That's why this discount that was made to us by the seller, I think, with consideration of those drawbacks, specifically with the sewage problem, it was a long-lasting and painful problem for us, and we have faced it for long periods of time. So I think the discount was appropriate and the price was adequate considering all these circumstances.
Thank you. And I'll recognize that the PCIE has received numerous photographs and even video of this sewage problem and some of the need for repairs in this apartment to provide supporting evidence to what you are telling us. So please know, I will be asking you questions, but also all of the materials that you have sent in have already also been reviewed. We just must discuss these things in the interview and ensure that the public and the HQCJ all have an opportunity to hear your responses out loud in your own voice. Can you please, still about the apartment, can you please explain the source of funds that your mother used for the purchase of this apartment?
So the apartment was purchased with the costs obtained from the selling of another apartment in Zaporizhia. So one apartment was sold, and then in the wake we bought that apartment.
And there is some issue with your declarations in this period. In your declaration for 2020, you indicated that as of October of that year, you yourself became the owner of the apartment, but also you have declared at other points that you were actually leasing the apartment from your mother, but that you were living there free of charge. But you stated as the basis for using the apartment that it was a lease. So can you please go through and explain this situation? Explain if there were errors and what steps you took to correct them in your declarations. And please explain your understanding of the law as it relates to declarations for judges.
Back then, in fact, I did state that it was done on the basis of a lease, probably because the declaration allowed me to do that, because legally speaking, I qualified these relations like this. So we just paid the communal utilities and lived in the apartment or with her permission, and I thought that from the civil point of view it could be qualified as lease, but indeed I didn't pay attention to the fact that lease means paying for staying, for living in the apartment. I overlooked this definition, and I did not reflect the nature of the legal relations that we had correctly, because in fact it was free of charge stay in the apartment.
Can you go into a little bit more detail about the second part of my question about the responsibility of judges for declarations and any steps that you have taken since making this error to ensure that your future declarations are correct?
Of course, I make it a point to correct my mistakes, and I try not to repeat them. So in part, I have already provided explanations to the anti-corruption agency as to other issues that may arise today. But I will also provide explanations to the anti-corruption agency NAZK regarding the incorrect data in the declaration.
Okay, and then in 2020, the ownership of the apartment changed from your mother to you. Can you explain the legal grounds and the circumstances under which the ownership of the apartment was transferred from your mother to you, including the type of transaction, and you can describe any of the documents and materials that you have already shared about this apartment with the PCI?
So I became the owner of that apartment on the basis of a gift. My mother gifted it to me. It was her wish to do so. And at that point, we have stayed for 5 years in the apartment. We had a child, so we were a young family, and she wanted us to have our own apartment, and therefore she gifted me that apartment.
Can you explain? There's a second part to my question. Please explain the documents that you have shared with the PCIe that support this information.
I sent you the copy of the act of gifting that apartment.
Thank you. Because the public doesn't have access to our internal documents, I will ask you to be very clear, to describe out loud in your own words materials that you have already shared in writing with us so that it is transparent to the public. The purpose of my questions is to encourage you to tell me some of the things you have already shared in writing. Please understand. My next question is about the amount that the apartment was sold to you for. You indicated in your materials that the apartment was sold for a symbolic amount of 20,000 hryvnia and not for the declared value, which was approximately 193,000 hryvnia. How did you determine the value of 20,000 hryvnia, and why did you choose to execute the exchange as a sale instead of a gift?
I
would like to clarify, it was not a sale, it was a gift. I indicated that. So it may be an issue of interpretation. I may be hearing something different. So the apartment was gifted, it was not sold, and 20,000 hryvnia, as I indicated, it was just a random amount that the apartment was evaluated, because the law did not require us to state such a sum, given the nature of the relations, and I stated the amount of which by which the apartment was bought, and then the amount for which it was gifted.
Thank you. And my question is about why did you choose this amount as the value? Why did you not declare that the value was the same as the purchase value? Is there some legal reason why the value was declared as lower?
Back then, we would just use the fact that that value did not influence anything, because we would not have any implications, any commitments following this transaction. I don't remember why we decided on this number in particular. I cannot give you the reason, so I can only explain it by this type of circumstances.
Thank you. I'm going to move on to a new area, a new topic. Regarding conflict of interest, according to your questionnaire for the position of judge, you have indicated Hanna Lapshina, who is a lawyer, as a person who can recommend you, can be a reference for you. Ms. Hanna Lapshina was a representative in various cases that are pending before the Priazovsky District Court of Zaporizhia region, which is the same court where you were a judge. In addition, according to available information, Hanna Lapshina and your mother have been business partners with a law firm in the past as beneficial owners. So can you please help me to understand how you manage conflict of interest with this relationship with Hanna Lapshina as a lawyer who appears in the court where you are a judge?
В 2003 році була
In
створена
2023, that law firm was set up, and in 2003 it was set up, and it lasted until 2007. And as my mom explained to me, my mother explained to me, all the tax returns were with zeros, and then my mother started providing services on her own as an independent entrepreneur, and she engaged in lawyer practice. And in 2019, my mother stopped her professional activities, and she did not maintain any kind of relationship, either professional or personal, with Hanna. So at one point, my mother wanted to exit that law firm, but she did not do it in the end. And in fact, I knew about the existence of that law firm at some point, but based on the circumstances that for whole my life, I haven't seen my mother really engage actively. I didn't think that it could be a problem. I didn't think it could be a conflict of interest. And in this case, yes, I indicated this woman as someone who could recommend me, and she was defending a party in the case that I considered. And in that case, yes, we had professional interest crossing ways. And in 2019, I was appointed judge. That is, to be more precise, September 2013. So each of us just did their work in parallel, and we cooperated as colleagues in one office. And therefore, I informed you of the fact that we had professional interests in common, and I did not self-recuse, and she did not either, and I didn't see a problem in this. After I was appointed judge, all the professional relations, or maybe personal, we didn't have any, and we haven't crossed paths for some time. And I would also add why she was indicated as someone who could recommend me is not because we had any personal relationship. I just stated the those who could recommend me in the chronological order, just in case you would need a recommendation from someone, because she has seen me as a lawyer, she has seen me as a judge, and she also was my scientific advisor. So she could provide you with as full picture as possible about my professional personality. And I also, I actually didn't even talk to her previously about the fact that I stated her as a referee in this competition.
I'll move on to a new area. You have explained that your mother-in-law, your wife's mother, is currently employed with the High Anti-Corruption Court. She is in an administrative role. She's not a judge. How do you assess the potential risk for conflict of interest arising from this situation, and how would you handle it if you were a judge at the High Anti-Corruption Court?
Наскільки мені відома мати
So,
моєї
to my knowledge, my
my
mother-in-law works in the High Anti-Corruption Court, and she registers the incoming correspondence. And because there are no relationship of subordinates from which conflict of interest might arise, I don't think there is a problem with this. And even if it arises, then we will abide by law and regulate it the way the law requires us to.
Can you explain to me some of the duties and obligations that the law would require you to do? For example, how would you talk about your work when you were visiting your mother-in-law at her house, for example? Or how would you make any modifications to your life in order to comply with the law? Please explain to me what the rules are.
Ну, ми не проживаємо разом.
So we don't
Моєї дружини
live together with my mother-in-law.
щодо конкретних заходів.
And regarding concrete steps that I will need to take, I'm not really ready to give you an answer. But in fact, I don't talk about my job, my work at home, because this is not ethical in the first place. Talking about it at home. Therefore, I believe that the duties of judge and the duties of an administrative specialist do not really cross ways, and there is no conflict of interest in this situation.
Okay, I'll move on to another area of questions. You had some issues with tax litigation. So there was a ruling of the Zaporizhia District Administrative Court in 2017 regarding a review by the Melitopol Tax and Inspectorate of your 2015 asset declaration. So following this review, the tax authority concluded there were some inaccuracies in your declaration, and they sent that conclusion to several bodies, including NABU, the police, the prosecutor's office, and a district court. You then challenged the tax authority's actions in court, but there were issues with technical issues with your claim, such as non-payment of a court fee and other issues with your challenge to the tax authority. Can you please tell me about this case, and what were the specific inaccuracies that were established by the tax authority about your declaration in 2015?
За 2015 рік дійсно
For 2015, indeed, the tax body conducted the check, and I received a notification about the establishment of inaccuracies in my data in the declaration of 2015. And I received these messages, if I'm not mistaken, at the end of 2016. The essence of that message was regarding 3 points. The first one was that I declared my place of residence in Section 2, but I did not declare it as the object in Section 3. That's the same apartment that we were discussing today, where I resided starting from August of 2015, and accordingly until the end of the year. Secondly, was that the tax body specified that they identified that citizen Didenko Yevhen Volodymyrovych without specification of any other identification data had a registration of 2 land plots in Vilnyansky, if I'm not mistaken, or in some other district of the Zaporizhia region. And according to my explanations, and they referring to that I explained to them that these were not my land plots. I never registered them. And the third point was a completely different person. Maybe that was their technical mistake from their side. But anyway, all of that was specified in my... Indeed, back then, I provided explanations to the tax body about all of these circumstances. I referred to the fact that indeed there was no clear procedure of submitting declarations, so that indeed, since I thought that I didn't have back then any agreement or any registered right or even registered place of residence in this apartment, I did not have any expenses on its sale. I thought that I was not supposed to declare that object in Section 3, and that it would be enough for me to declare this apartment in Section 2 as my place of residence. And with respect to the land plots, I've also provided explanations that I did not register any rights for them. Probably that was a coincidence of the surname, name, and patronymics with another person, because I even never visited that area. After that, I decided to submit a claim. Back then, there were many claims like that, according to the case law that I was reviewing regarding this ground. But really, once they returned it because they accrued the court fee that was too big for me, then I submitted another claim. I decreased my claim demands, but it was also returned, so I had to pay it again. And when they returned it for the second time, in the ruling, the judge drew my attention to the terms for the submission of the claim. According to the law, I was calculating these terms as 6 months, but the judge thought that the term should be 1 year as a relationship that is related to civil service. And accordingly, having assessed that indeed there was this issue regarding terms, and after that, there started emerging case law. Maybe these were even courts of appeals. And that case law was showing that these conclusions of the tax body cannot be challenged at all, because that is not some decision of the tax body. That is its opinion. And you can challenge only the decision that has been adopted based on this conclusion, if they had adopted such a decision. And looking at this case law that started appearing, that maybe indeed I violated the terms, I decided that I would not challenge that further. If public authorities would want any explanations from me regarding that matter for adoption of some decisions, then I will defend my positions within the framework of respective procedures. And with respect to these 2 land plots that they mentioned, I would like to draw attention that they did not state that these were my land plots. They just said that they identified these land plots based on their surname, name, and patronymics, without the date of birth, without the identification code, without the place of residence. And they referred to my explanations that these were not my land plots. So it was not even clear to me what was the point of including this fact into this notification, whether I should consider that as accurate or inaccurate. Also, according to this notification, these 2 land plots, as specified there, were registered in 2007. I would like to draw attention then, in 2007, I was a student even. That's it.
I'll stop you there. Thank you for that information. We're very short on time, so I'll just like to ask you a few more questions. You've been a judge since June of 2022. And previously, you were a judge from 2013 until 2022 in the District Court of Zaporizhia, but you have been in Kyiv since 2022. So actually, for many years, you've been a judge. In those two courts, can you tell me about any complex criminal cases or financial crime cases, financial litigation cases, where you have had to deal with issues similar to the types of cases that are dealt with at the High Anti-Corruption Court? Please tell me some examples of cases that involved complex evidence or financial literacy, financial information, and how you handled those cases. Give me some examples during your many years as a judge.
Євген Володимирович, перш ніж ви відповісте,
Before you answer, I have to inform that Shevchuk Galina Mikhailovna and Volkova Lyudmila Mikolayevna have joined us. Thank you.
Я наводив
I've provided to the Commission those cases that I found that directly were considered by me as corruption criminal offenses. I can say that these indicator cases were not complex. Well, these were cases with the admission of guilt or plea deals, so these were not some complex legal battle. Right now, I have these complex cases in my proceeding, but I still continue considering that right now. I have cases now in which the person is charged under Article 191 regarding abuse of public position. For example, 80 volumes of case materials that have already been studied under this case, and the case is still ongoing. It's not complete. That's why I'm trying, but these complex cases, unfortunately, cannot be considered very quickly given the workload in the courts and all the other cases that I also have to consider.
Can you tell me about your experience with financial matters and accounting, or with anti-corruption law as part of your continuing legal education? Have you taken any additional classes or read books or reviewed cases in your continuing legal education with regards to financial matters, accounting, and anti-corruption in general?
спеціального навчання щодо
Special training regarding economic matters. No, I did not have any like that. But as I've mentioned, I have similar cases in my proceedings and I have to deal with them. And with respect to the anti-corruption training, in 2021, I completed a seminar regarding anti-corruption legislation. It was not long. These were only 4 hours of this seminar. These were general matters regarding declarations, provisions of the anti-corruption law. They were emphasizing some points from that, and that's it basically.
And just a final question, can you please tell me a little bit about your PhD dissertation? You've told us that in 2020 you defended a PhD dissertation about the realization of the right to a fair trial and consideration of cases on administrative offenses. Can you please tell me how this PhD, why you chose this topic and how it relates to your work as a judge?
на тему цієї дисертації мене
Regarding the
надихнуло
topic of
те,
this
що
dissertation, I was inspired to choose this topic by participation of the course on human rights protection that was organized by Ukrainian Helsinki Union. It was a large course, and among other things, it covered the right to a fair trial. And that's why I thought that this was an interesting topic. Besides, the topic should have some academic novelty. And back then, there were no comprehensive studies in Ukraine regarding this exercise of the right to a fair trial in the sphere of administrative offenses. That sphere for Ukraine is outdated because it has not been reformed for a long time. So I thought that it would be correct and useful back then to choose the topic. And as a result of that, I saw these suggestions regarding the draft law that would allow to introduce amendments in order to bring national legislation into alignment with international standards.
My final question is about your personal emotional reaction to the experience of intimidation. All people throughout our lives experience sometimes aggression or intimidation from other people, whether we're as a child in our daily life. Can you please explain any situation, think of an exact example from your life history, and explain how you reacted to a situation where you were confronted with intimidation or aggression from another person. You can choose any example from your childhood or from your life as an adult, from your professional life. How do you react emotionally when you're confronted with intimidation?
Мені зараз важко сформулювати.
It's hard for me right now to provide some specific examples. I can only say that during, for example, consideration of criminal cases, there were situations when persons, for example, were very aggressive during the court hearing. As for that, there are procedural measures. I removed them. Even I had situations when I removed them from the court hall when all of the other response measures were exhausted. And then I continued hearing the case. But some specific examples of intimidation. Well, what can I say? When we were leaving the occupied territory, that was also a very unpleasant experience. Over 20 checkpoints that we had to go through. But probably that's not the situation that you're asking about. That's a slightly different thing.
When you think about yourself emotionally, do you feel that you respond calmly to situations where someone is aggressive, or do you feel like you respond in some other way? How do you find the experience of setting boundaries as a judge?
В залежності від того, хто поводиться агресивно,
depending on who actually behaves aggressively and what the situation is. If these are parties to the case, to the process, that's one thing. We know how to respond. Everything is envisaged in the law. But if it's daily life, if someone behaves aggressively, I try to avoid the conflict, let's say it so. I'm a person who, responds rarely with aggression to another aggression. I try to close myself from this situation. For this situation, not to touch me, let's say it so, if it's possible. If it's not possible, correspondingly, then I will withstand for my interests in this situation. But so I'm a person which is not aggressive. No, it doesn't mean that I never have any emotions inside myself. Of course, I have emotions and I worry regarding different conflicts and cases, but I'm not an aggressive person, generally speaking.
Thank you. I have no further questions. I'll turn to my fellow members of the PCIe and to Mary on the screen if you have any questions.
Mary, you have any questions? Norm? No, sorry, Mary, huh? No?
Thank you.
John, I have a question if you don't mind, because I've been reading that it's about the gifts of your family. Because I've read that in 2020 you got a gift of 220,000 hryvnia, in 2022 of 90,000, in 2024 of 152,000, and that you explain because you say that your mother has a good pension and that she lives on a very small amount of money and that she's able to give it away. But I noted that you have two brothers. And being a parent, I would find it very likely that your mother would not only give money to you, but also to your brothers. And if I then make the calculation, it becomes difficult for your mother to give those amounts. So can you please explain how that is possible that your mother gives away these amounts? Or is she only gifting it to you and not to your brothers? Or if she gives it to everyone, how are you able to explain that your mother had enough money to do this?
Щодо двох братів,
Regarding two other brothers, I would like to clarify that by my mom, I have only one brother. So brother with whom we have the same mom. Another brother, that's son of my father from another marriage. So that's another family. And I have seen him maybe only once in my life. And I found out about him, just a year or two before the full-scale invasion. So my brother, who is my sibling, and we have one mother, he's older than me by 18 years old. So my mother had helped him in the past, but now they have also their own personal relations or circumstances, let's say it so. And I know she also provides him some financial support, but sometimes it's in the non-significant amount of money. But in the past, some time ago when he was young at Melitopol, my mom also helped him to purchase a one-bedroom apartment. So my parents also gave him money at that moment. So that's how it is.
Okay. And what I read is that your mother saves approximately 31,000 hryvnias per month. And that would mean that she's living on 17,000 hryvnias per month, which seems to be a very small amount to live on per month, especially because she's a former judge, so quite used to a good life.
Я хочу звернути увагу
I
на
would
те,
like to raise your attention that my mother is quite an elderly person. So now she's 79 years old. Starting 2020s, My father started being sick, so he needed constant support and taking care after him almost all the time. So since that moment, they didn't have any travels, any vacations, any even, to go for lunch somewhere at a restaurant. No, all the time they have been staying at home at that moment before leaving the territory. I also tried to help to take care after him. So those amounts that I mentioned, I need to say that our pensioners, usually in Ukraine, they get pensions of 1,000 hryvnia, and they know how to live at that amount. But again, those sums and those calculations were very approximate, because unfortunately, I can't give you strict, sharp calculations. But I just didn't make up those sums. No, I asked my mother, what is the sum of your expenses? So that I took that sum, I noted down, made calculations, and drafted the relevant budget.
Thank you. No further questions from me. Please over to Mr. Konius, the chair.
Руслане Михайловичу, будь ласка, слово вам надається.
Ruslan Mikhailovich, that's over to you for your question. Thank you.
Пане Євген, у мене буде декілька
Mr. Yevgen, I have a few questions to you. Some of them will be overlapping with the questions that you have been already asked right now. Others will be new ones.
Передусім,
So just
я б
first
хотів,
of all,
щоб ми трошки
I would like
пояснили ваше
to clarify additionally
сприйняття і аналіз
your perception and analysis of yourself as a professional
і
judge.
історії, коли,
And from this professional perspective, we would like to know your analysis of that situation when the electronic declarations process started, and there was the tax inspectorate report regarding you. You tried to challenge it. For Ukraine, it was the very first period of start of electronic declarations. Indeed, it was ambiguous. It was challenging. The practice, how to do it, there was not much of it. So the problems that were there at the beginning, we don't have them now. But at the same time, I would like to understand how you have analyzed that situation. I don't object or argue your argument regarding lack of justification from the side of the tax service. But that's your approach. So, responding to the PCA questions, you replied that further the information was provided by the judicial doctrine that the act itself in such cases can't be challenged, but only other decisions should be challenged. Those decisions which actually define legally meaningful consequences. But the relevant approach in the context of the results of the tax inspection had been formed by the judicial doctrine quite a long time ago. For example, everyone knows that the tax notification of the decision made based on the results of the review could be challenged rather than the act itself. I understand that you are not the judge of the district court which considers tax cases, but you are a judge of the general court which considers also criminal cases, including cases under Article 212 regarding tax evasion. And I think that you should have known that the fact of drafting of the act doesn't constitute the fact of tax evasion, doesn't constitute the fact of failure to provide accurate information, etc. So my question to you is the following: why, for you, it was a surprise
некоректність оскарження самого акту
that
перевірки
that it's inappropriate to challenge the act of review before the moment of the tax inspection or any other authority makes a decision on legally meaningful consequences. So my question to you, why did you decide to challenge the very specific act of the tax service? I decided to challenge it because I didn't agree with the conclusions stated by the tax service, which stated that the data that I provided were inaccurate, not trustworthy. So I understand, I agree that I made a mistake in some things, but it doesn't mean that all this data wasn't trustworthy. I just didn't get this information that they asked about those land plots. Regarding this opportunity to challenge, when I prepared my claim, my complaint at that moment, I thought that it's possible. I also looked at the current practice at that moment, that such things were challenged. But then I reviewed the situation, I digged into details. I realized that it's not worth it to challenge further because it was not correct from the legal perspective. Okay, tell me. But as a judge, if as a judge of general jurisdiction, you have received indictment under Article 212 regarding the tax evasion, which was based exclusively on the act and rather than on all other decisions of the tax service regarding legally meaningful consequences and any other calculations and documents drafted by the tax service. What would you have done as a judge in such case? No, of course not. I would not have made a decision that would not have considered the case. Then, why did you think that the act of the tax review shall be challenged and shall become a basis for your challenging lawsuit? I just want to understand your logic as a court, as a judge. Unfortunately, I can't give you a detailed, justified reply as you want to hear from me, because unfortunately, I don't even have documents in front of me. What I indicated there in that lawsuit, unfortunately, I didn't store them. They are located on the occupied territory, so I don't have. So, to recall in my memory this information, I looked at other documents in order to explain to the Commission regarding this tax service and what was there. I don't remember. I don't see this lawsuit document. What actually I submitted as a complaint? What was my justification there? Yeah, Mr. Grigan, I understand that it was quite a stressful situation for you. It was the only situation when you challenged such a decision and legal position, sorry, but it's hard for me to believe that you forgot a legal position. Of course, if you did it by yourself, maybe you have involved the third person and you didn't dig into details of the document of your lawsuit, then it's easier to believe in such a situation. No, I did it by myself. Okay, you can't recall it. Okay, then, and if we don't have this document in front of us, then it makes no sense to continue questioning regarding this part. And I would like to ask you another question regarding your academic activities. And tell me, please, when did you start working on your thesis? So the defense was back in 2020, yes, in December. In December of 2020, the defense took place. I started my postgraduate studies. I think, if I'm not mistaken, it was back in September 2017. Till the end of 2017, I hadn't had any publications at all. I was at the beginning stage, I was like thinking about the plan, structure, content, the topic itself, and only in 2018 I started to issue certain academic materials, which then became the foundation of my thesis. Okay, then tell me, how do you treat the notion of the direct application of constitution provisions. I treat it as it exists, that's objective reality. So my question is about the following. When you started working on your work on 2nd June 2016, there were amendments made to the Constitution. I can't even assume that you don't know about it. The amendments were made to the section of the Constitution related to justice. And if before those amendments, the decisions should have been justified by the principles of legality, and it was criticized that it contradicts Article 8, where the rule of law is defined, but at that case, after those amendments, that problem was eliminated. So despite of the fact that the Code of Administrative Offences is indeed quite outdated, and it doesn't take into account so many different other nuances, and the amendments to the Constitution regarding general provisions on administering of justice by all courts regarding and including administrative offences were corrected. So just give me 2-3 sentences. What was the academic novelty of your work, of your thesis, in the context of the current version of the Constitution of Ukraine, specifically in relation to this part of amendments? So the academic novelty of my work was the following, that it was such full, comprehensive first study of the guarantees of the right to fair trial when considering administrative offences cases. And I reviewed and studied different stages of an administrative offense proceeding as different scholars defined, and different stages of the investigation as defined by different scholars, and as it was envisaged in the Code on Administrative Offences. I also defined different guarantees of the right to a fair trial which exist on different stages of the proceeding, how they manifest. I also referred to the doctrine of the European Court in correlated cases. And based on all this, as a result of this thesis, I drafted the draft law, and I suggested those amendments that, to my opinion, would have been useful and that would have allowed to optimize and mainstream such cases. Sorry for interrupting you. But suggested changes, suggested amendments to the draft law, that's about different thing. It's not about the academic novelty. So, just in one sentence, what is your academic novelty about? And the comprehensive nature of my study, of which I mentioned these guarantees of the right to a fair trial, when I studied the full picture during the whole process of the administrative offense proceeding, and even before it starts to be considered. And also I studied another issue. I studied the issue of lack of respect to the court, and it was suggested to consider such situations exclusively in written proceedings and to exclude participants to the case as subjects of such process. So I suggest to stop on this matter. I think everyone who got your reply. Let's go further. So tell me, please, you have not been involved into any lecturing or teaching activities? No. Not before the defense of your thesis, not after. Yeah, I didn't do it. Then, tell me, what was the purpose of writing your academic study if you are not engaged into any teaching activities? What was the purpose, the value of it? So, first of all, I thought that it's an opportunity for my professional development to extend my and scale up my professional horizons. That would be useful for me. And then I thought that after after such activities, after such work, I could start some teaching activities because my workload, my schedule, generally speaking, allowed me to be engaged into such teaching activities. But it happens that I didn't have an opportunity to start it. Okay, thank you. I have only 2 questions left. So in 2022, you were seconded to the Obolonsky District Court by the decision of the presiding judge of the Supreme Court. Yes. Then, so the procedure of the secondment at that moment was a little bit less transparent than the procedure that we are having right now. So can you tell me, can you explain to the Commission why you were seconded to the Obolonsky District Court rather than to any other court? How did you submit documents? How the decision was made? Was the decision made only by the presiding judge, or how? A little bit more details, but briefly. It will be hard to do it briefly because I need to tell you the whole procedure. Am I right? You know? So it's clear that the full-scale invasion started. The court suspended its activities. All we know it. And then you submit a statement or application. We know this story. Please second me to this court, and they didn't approve it. First, second time, third time.
Так вийшло, що ми з сім'єю опинились в Києві, і дружина на той час була вагітна. Я розумів, що відповідно до того переліку, який був...
So I understood that according to the order that existed, a procedure existed among judges for judges in small towns. So we needed to move somewhere, and my wife needed to give birth, and I wanted to stay in Kiev for some time. The list of judges that could move was an approximate one. And first I submitted an application about reappointing me to a different court in Kiev, and my application was denied. No, it was different. So I could choose 3 courts. First, it was Kiev, and then 2 and 3, these were district courts around Kiev. But they denied my application because I did not really choose the exact court properly. And then I was invited to submit another application. And the second time in my application, I stated the same circumstances, the pregnancy of my wife, and I also provided certificates that my wife is unemployed. And first I was proposed to go to Obolonsky district court, and I also stated another court in Vinnytsia Oblast and another court in Kryvyi Rih, in the order of favorability. And my application was satisfied. The first priority was satisfied, and this is how I went there. Thank you. And my last question, Yevhen. After the full-scale invasion, I think you know that the Commission is analyzing the decisions of deprivation of parental rights and granting caregiver status. Some judges may facilitate someone's evasion of conscription. And throughout 2022-2024, you only have several decisions where potentially those who could be conscripted potentially were granted the status of a caregiver or the status of a nephew or a status of the elder brother. In other cases, they were granted the status of son. So you granted the status to the man. The status to the man so that he provides care to his wife's grandma. And that looks far-fetched. Could you please explain whether you remember that case and whether there were no other relatives who could provide care in that family? Or was it just an excuse to avoid conscription? Unfortunately, I don't remember the circumstances of that particular case. What I can tell you is the following. So there is a general principle in such cases. First, this is a socially socially relevant case, and that elderly lady needed a caregiver, and the state should not assume this responsibility as long as the person has some relatives to do it. And we were in contact with the body of care, agency, institution of care, and we had a certificate describing the composition of the family. And based on the references from the center, the man also needed to provide certificates of his state of health. And those materials need to be, I need to refresh them in my memory in order to give you a very substantiated answer, but this is the general principle. Okay, thank you, Yevhen. And no more questions on my part, Oleg. Thank you. And regarding your question, I would like to clarify something. How many judges in Priazov District Court received reappointment to Kyiv courts? In Priazov District Court in Zaporizhia Oblast, during the full-scale invasion, just two judges received such reappointments. Me and another person was reappointed to Ivano-Frankivsk Oblast. Dear colleagues, in case you have questions, please go ahead. And please be very laconic because we are running out of time. So in order to build on the reappointment issue, so actually I can see that documents prove what you are saying. So the selection of priorities in different oblasts, as you mentioned, the list of judges that was proposed on the part of the head of the Supreme Court was not concealed, it was to public domain, and therefore there is a question how some judges made it to Kyiv even not being on the list. So did you do it on your own risk, or whether you made some consultations in the Supreme Court to clarify your circumstances for reappointment? How did you arrive at the conclusion that you could apply for the courts where it was not, there were no vacancies? So actually, judges faced a very complex decision. They needed to decide where to move. Some of my colleagues found that the list of judges was an approximate one. It was a rough list. That was the wording. And because it is rough, then exceptions could be made. Some could be removed, others could jump in, and there was also a sort of meeting, a video meeting that we had with the chair of the Supreme Court, where they explained that some judges from the list could be removed from it. And then my colleagues, okay, I got it. Let us be more brief. I get your answer. So did you apply in person, or did you apply for what? For the reappointment? I sent my application to the email. Did you attend an in-person meeting? No, I didn't. Then cases that you have as a judge now, I considered the decision of the High Commission of Judges and the Public Council of Experts regarding your reappointment to Obolon suit, even though you asked for Podil district. You were also involved in cases of related to Maidan, collegial cases. And in Obolon court, the workload is lower, but the social impact of the cases that you are taking is really important. So out of those 3 cases, which is completed? So actually, I asked to stay in Obolon in order to be able to finish the cases, in order not to burden my colleagues. And out of those 3 cases, 1 case is complete, related to the Revolution of Dignity. The case that was a collegial one, and there is a verdict there. Another case involves 4 individuals. 2 cases are closed because of statutory limitations, and the other 2 are still being considered. So, based on your prospects in the competition, you didn't have time to consider the cases. But yeah, probably yes, that was what kept me from finishing them. Participation in the competition in particular. Thank you for this opportunity to ask my question. Melnik. And my question relates to your declarations. So in your declaration in 2022, you said that you are leasing an apartment 83 square meters approximately, and foundation for investment guarantees is the leaser. And what kind of contributions do you make according to this agreement that you concluded? In 2022, we concluded an agreement of leasing agreement, and that legal entity was indicated as the owner. And I paid 14,000 hryvnia monthly according to the agreement. Then the owner changed, and as of April 1, 2023, the leasing agreement was reconcluded with a different owner, line sale, and I actually checked that they are the owners. I checked the information in the register, and the monthly contribution was increased, and then we reviewed the leasing agreements because they keep increasing my monthly contribution. And in declarations to 2023-2024, I stated a different owner by mistake because I filled the declaration based on the previously submitted declarations, and those data, actually the data about the previous owner stayed there, and I didn't really pay attention to that. But currently, I made conclusion, like lessons are learned, and I submitted an application to NAZK to correct that. How did you find this apartment? I found this apartment with the help of a realtor, with a manager. When we arrived to Kyiv, our friends let us stay in their apartment for some time, but they then needed to host their relatives from Kharkiv, and in one day we had to move, and we had to find an apartment very quickly, and we used some ads, some announcements in the, and this is how we found them. Do you have an agreement? Yes, of course. I submitted all of them, and I pay the lease. I have all the checks. It's all official. Okay, so it's just a leasing agreement, and the subject is a leasing of an apartment. Yeah, a 2-bedroom apartment. Okay, thank you. Hi, Alexey Milyan, member of the Commission. From July 25 to September 2025, there were several requests to get full access of the register of court decisions. And those requests have your identification data regarding criminal case 1818 are the last numbers, and requests also related to certain individuals. The criminal criminal case relates to illegal transfer from Ukraine to abroad. And could you please state the motives of your request? Whether your search corresponds to this one, and could you share? I don't remember. I have cases regarding illegal border crossing, illegal transfer. But one part of subjects, they were involved in other criminal cases, so it may be related to the one you are quoting. So I don't remember, but what is occurring to me may be this. So you don't have specialization in your court? No, we don't, but my specialization is that I consider criminal, civil, administrative cases, but I'm not an investigation judge. Thank you. Then another question. When the council members asked you about Lapshina, when was the last time she participated in the court sessions? So, as far as I remember, it was the only criminal case when she participated in the court session. When was it? I checked, but I didn't find any other information. It was 2020, if I'm not mistaken. Did she have civil cases? I don't remember. So I checked this. I checked it, but I didn't find such information. I might be mistaken. Okay, got it. And regarding your skills in case consideration within the High Anti-Corruption Court, under which circumstances can we determine a bribe and qualify an act as a bribe? Illegal enrichment. As long as it is voluntary. Could you compare the request to receive a bribe and a proposal to give one? So if there is a act of demanding a bribe, then there is force, exercise of force. And then there also may be blackmailing or threatening. So some unfavorable circumstances may occur unless the individual provides a bribe. And the judge or whoever benefits from that. Yeah, thank you. Then just a clarifying question, follow-up question. The term for your leasing agreement, what was that? 6 months. So it was a long term. Yep. Thank you. Then because we are talking about skills, then we could talk about the practical task too.
Do you remember the declaration? And the question was after another candidate as well. You confiscated the laptop from which the declaration was filled in. Back then, we were saying that we can put the situation into an absurd one. For example, a chair can be confiscated on which the person was sitting, the table on which the laptop was standing, or even an apartment or a house, if the declaration was filled in some house or apartment. Don't you think that this way the situation can become even absurd if for example, if the declaration was submitted from the phone, then the phone might be confiscated. I think that any situation can become absurd, but in these specific cases, formally, these items are subject to the science of items of criminal offenses, and there is a respective case law. I don't know about how the judges of the High Corruption Court resolve these issues, but during consideration of criminal proceedings, which are related to some produce of intimate nature, everything is confiscated, destroyed. All of these laptops from which, for example, some broadcast and dissemination of these videos was done. A good comparison, thank you. No more questions. If that was the totality of crimes, yes, maybe such confiscation should have been applied. Okay, no more questions from the colleagues. Mr. Robert, what about you? Do you have any new questions?
I'm just looking around me. Mary on the screen? No? No, thank you.
Дякую.
Thank you. Mr. Yevhen, now you have up to 1 minute to inform us about what you want to inform us. Thank you for your attention. I don't know whether whether you are satisfied with my answers, but at least all of them have been honest. Thank you. Thank you. I'm announcing your interview over, and I'm announcing a technical break. Thank you for your participation. Goodbye, and